Right, everybody. Welcome to this special edition of the Compliance Guy. I'm Sean Weiss, and as always, I want to begin by saying thank you all so much for tuning in, logging on, and just hanging out with me and my special guest for a little while as we talk about some of the coolest things going on in healthcare right now. As I said, this is a special edition because I have on the man, the myth, the legend. To me, probably the best litigator in healthcare that I've worked with in my 28-year career of doing this kind of work. And I'm talking about Ron Chapman II of the Chapman Law Firm. Welcome to the program, counselor.
Thanks a lot, Sean. I appreciate you having me for this special edition.
Yeah, I am really excited about this one because if you've been listening to the Compliance Guy podcast over the last week and a half, you know that I was brought in as an expert witness. At first, I was a consulting expert, and then I was asked about a few weeks prior to the trial, hey, we kind of need you to fly up here and get on the stand, which is, always good for the nerves. But here's the deal. This case was absolutely fascinating from the very beginning all the way to the very end and all of the little intricate parts in between. Ron's going to provide us with really a breakdown, but this case is the United States v. The Pain Center. And we're just kind of calling it that for simplification so we can just kind of, without having to go through all the technical numbers and terms and things of that nature. But basically, this case stemmed from an OIG investigation. And again, I'm just laying the groundwork, and counselor is going to go ahead and really provide us all the details. But this stemmed from an OIG investigation that took place. And in my opinion, as an outsider looking in at first, it was fatally flawed for a number of reasons. And it became completely understandable as to why it was fatally flawed as more and more evidence became available to us as I got an opportunity to really understand what was going on. Long story short, this is one of the largest healthcare fraud cases that I think has ever existed. $484 million, if I'm not mistaken, with only 6 defendants. One of the defendants had been in prison, if I'm not mistaken, since 2018. Multiple requests to the parole board were made, and they were denied for various reasons. But with the leadership of Ron Chapman and others from his firm, they got a trial acquittal on, I believe it was 56 counts against four of the 6 defendants in the case.
Yep, 54. Yeah.
54. And for 4 of the 6 defendants, because 2 of the defendants, I believe, took plea agreements early on. That's right. Decided to turn state's witnesses.
Yeah, so we'll talk about that. It's a common thing that we've always discussed about who you hire as an attorney, but we'll get to that.
All right, so I'm going to stop there because again, I really want you to hear this from Ron Chapman himself, because I think the explanation that you're going to get is going to be just fascinating. And once again, this episode will prove why you only hire experts in litigation of health care fraud, healthcare issues, because if you don't, you wind up making significant mistakes. So let me stop there. Counselor, why don't you kind of take us from the start, and I'll kind of ask some questions as we get going here.
Yeah, let's break it down from the beginning. I think we've got a lot of ground to cover here, but I hope that folks can learn exactly why this case turned out the way it did, and some of the strategies that we used to get it there, which we'll get to, but let's lay some groundwork. So Dr. Bothra had been in practice since probably 2007. He was a surgeon, but opened up a private practice in Warren, Michigan, which is just at the doorstep of Detroit. And started getting into interventional pain ended up getting certified himself and hiring another doctor, Dr. Edu. The practice started to grow significantly. We see this rapid growth without a compliance plan is a recipe for the government to start asking questions, right? When you start to become an outlier. And that, if you could, fault Dr. Bothra for anything, it was not contacting somebody like me or you early on to get everything right. But that's not criminal, right? That's just
Right.
a compliance issue. So he then starts hiring more talented interventional anesthesiologists, one of which was Dr. David Lewis, my client. And lo and behold, 2018, the place gets raided, everybody gets indicted, and the government releases to the press that same day that the entire clinic was fraud and there was $484 million worth of healthcare fraud. We wanted to go to trial quickly, but the COVID pandemic hit after I arrived on the case, and the case was continuously stayed. We eventually got it to trial. And here are the shortfalls of the government. And I'll just digress for a second. First, we're seeing that the prosecutors who are taking healthcare fraud cases, while they may be part of a healthcare fraud division or a DOJ strike force, they have this difference of opinion from me, in that they believe that healthcare fraud, because they've determined that something is fraudulent, absolves them from any responsibility to follow Medicare's guidance, proper auditing, statistical sampling methodologies. And when I argue these things in court, both judges and prosecutors are looking at me like, this is a criminal case. You're arguing civil stuff. Well, this trial proved that that's not true. We just needed to convince a jury that these things need to be followed. And that's where your testimony became so vital in the case. And I also want to mention, I couldn't think of a better place to say the first words about this case and how it turned out than your podcast. Not only were you involved in the case, but I think that your listeners, the collection of people that are devoted to listening to your podcast, will really get something out of this. And as we continue to be on the podcast and have the roundtable that we're ready for, I think that we can continue to provide more information about how this model that we've developed will help people. So we get to trial, and here's our defense theory. Government came up with their theory from the beginning of the case after only sending 6 charts to their expert for review. 6 charts. They argued $484 million worth of fraud. The entire practice was fraudulent. Every code, every procedure, every patient. And that's just an untenable theory. These prosecutors want to make headlines by claiming large amounts of fraud, but when it actually comes to proving it, that's a different story. So knowing that they had decided to anchor their boat to this island, right, of $484 million worth of fraud, we felt as a defense team, and as the only healthcare expert on the defense team, well, Al Rogalski knows healthcare very well as well, but I felt like I had to carry this burden a lot on my back for the entire defense team. But we figured that if we could convince the jury that this all fraud theory was complete BS, they would at least not trust the government's representations. And I say it in the book time and time again. Trials are about what, Sean? Credibility, right?
Credibility.
They're all about credibility. And when you can find and show the jury that the government doesn't have any, they'll look through that evidence with a critical eye. So your only job as a defense attorney during trial is to erode the credibility of the prosecution and get the jury to see that they're being sold a story that just isn't true. So we attacked this $484 million number. Well, how would we do it? We did it by doing the government's job for them, right?
That's right.
We did somewhat of a statistical analysis of the practice. We had our expert review the specific files that they looked at to cover down on that and show that there was no fraud committed. But then we put you on the stand to testify about all the things the government must do according to their own regulations that would be required to prove that the entire clinic was fraudulent. Once the jury heard all of that, they didn't have to go too far to realize that this case was a political hack, that it never should have been brought, that they were overselling it. Now, as trial progressed and this all fraud theory completely eroded, we were sitting and waiting for the government's closing argument to see if they were going to stick to their theory or if they were going to back down and maybe try to isolate one or two counts. Well, these prosecutors didn't back down. They doubled down on their all fraud theory. They just tried to argue that our statistical evidence was not reliable. But then all I had to do is stand up and say, where's the government's statistical sampling? The courtroom was packed with prosecutors during the closing argument. Investigators have been all over the place. We had poor Ryan Vaughn fly all the way in from Bali to present some numbers, and they've got agents right over here in Detroit who can do this work easily. They want to tell you something, but they don't want to prove it.
Right.
So 7 weeks of trial. A lot of our defense was focused on this theory of disproving all fraud and showing the government did not show their work or even do their work properly. A couple of other elements that are important to point out. First, you gotta have the defendant testify, period. If you're facing these kinds of allegations, you've got to. Dr. Bothra chose not to testify. That's his choice.
That's right.
Dr. Rousseau chose not to testify. That's his choice. Thankfully, Dr. Edu and Dr. Lewis, my client and a very good attorney, Bob Harrison's client, took the stand. And what we did during our client testimony was try to provide all of the substance that you would likely hear from these other people to make up for it. So we were able to somewhat overcome that burden. That was incredibly important. And then just solid cross-examination of every investigator about what they could have done to prove the theory and what they didn't do to prove the theory. A court security officer, we call them CSOs, came up to me, a very nice man, observed the entire trial, said, I've observed probably hundreds of trials over the years. I watched your closing. Everything was fantastic. This case shouldn't have been brought. But he said, you know, the most impactful slide that I saw in your closing was, where's the medical board? Where's the audit that was conducted and the provider education that you established, Sean? Yeah. Where was the Warren Police Department, the city police department, to say this place was a cesspool of fraudulent activity? Because they would know if patients were complaining or if there were drug deals or anything in the parking lot.
Yeah, you would think so, right?
Yeah, exactly. Where was, I think I might have mentioned it, but the Board of Medicine, where was JCO when they were running through this practice, certifying it? When did they say there were any problems? So I think we always have to remember that when we're dealing with a case like this, we don't just look at the surfaces of the government's case and try to attack them. We also have to look at the gaps. Because when we do that, when we play to those gaps in the government's investigation, we can create an almost impossible burden for the government to overcome unless they make really good use of their 4 or 5 weeks of testimony that they've got in terms of putting witnesses on. This is, of my last 5 trials, we've got 4 acquittals on the substantial issues in the case. 3 of those were complete acquittals, no questions. One of them, the Dr. Campbell case, was a conviction on some minor issues, but an acquittal on all the majors, including distribution causing death. Of those 5 cases, one of them is up before the Supreme Court. So we're really looking at 4 acquittals and then 1 case that soon, sometime today, the Supreme Court will decide on. That's Naum versus United States. Our trial record is unmatched, and I don't mean to brag about that, but I think that it's important to note that for one reason only. When I decided to go and get a healthcare education and learn all of this stuff and start applying that to defending clients, we start thinking with the Civil False Claims Act attorney's mind and applying that to these fraud cases. And as we've been able to do that and put a team together that's able to do that, the results have been astounding, right? These cases all should have been brought as False Claims Act cases. And so if we take a lot of those strategies from those cases that we would use, sampling and extrapolation, for example, we can apply that here and we get tremendous victories. The juries reward us for it. And that's one of the reasons why I created Chapman Consulting Group, so we can apply that model to other criminal cases across the country.
Don't you think, Ron, that one of the reasons why we're not seeing as many FCA cases being brought and we're seeing the transition to more healthcare fraud statute cases is because the healthcare fraud statute really allows prosecutors, if you will, to paint with a very broad brush. And the same burden that would exist in an FCA case isn't the same standard or same burden to a certain degree in a healthcare fraud statute case. And what I mean by that is under the false claims statute, there's a provision in there that simply states if reasonable persons can disagree on whether or not a claim was false, then the government has failed to establish that there was a violation of the False Claims Act. Am I overstating that, or am I misstating that?
No, you're absolutely right. And this is exactly why the prosecutors are bringing more criminal cases. We have this situation, and to borrow from Maverick in the first Top Gun, we're inverted, right? You would think that the False Claims Act burden would be lesser than the burden required to put somebody in jail for up to 20 years, 10 years for healthcare fraud, 20 for wire if they decide to charge it that way. You would think that it would be harder, but it's not, and this is partly because of Escobar. I think Universal Health, Escobar. The materiality requirements on the FCA side are very, very stringent, and you actually have to prove it. But those protections have not translated technically to the fraud world. So in this case, the one that we're talking about, the Pain Center case, the government simply stated in its indictment, because it could convince a grand jury, that the defendants improperly billed Medicare for procedures and visits. They basically said they did everything wrong, right?
Right.
They didn't have to specifically plead what they did wrong. So then they went fishing at trial and said, well, too many 99214s, too many procedures, right? But they didn't actually have to prove to a grand jury that the claims were false on their face and there were material misstatements made, because Escobar has not technically been applied to criminal decisions. I've argued to appellate courts and to district courts that Escobar should apply because, as the Supreme Court said, the materiality standards in Escobar are exactly the same as the materiality standards. I think Justice Thomas wrote the opinion, a popular guy these days, are exactly the same standards in fraud cases, but district courts aren't applying it. That's my next mission, right? We got a good decision on the Supreme Court opiate stuff. I'm happy about that. Naum is going to pave the way for that. It's time to transition into getting district courts and circuit courts to understand that if you want to bring a healthcare fraud prosecution, on that indictment, you need to plead material false statements and say exactly what they are.
It's interesting. I actually wrote a paper on Escobar. I wrote an entire position paper on Escobar. It was probably when I joined LinkedIn, it was probably one of the very first posts that I ever did. And it was interesting because I felt like, it was such an important case for so many reasons. And maybe it was just a little too soon for when I posted it. But I think in having this conversation, I'm going to dig that one up from the archives. Tell you what I'd like to do, if you're cool with this, I'd love to send it over to you and maybe update it a little bit and modernize it and then push it out as a co-authored paper if you're willing to do that.
I'd love to. And we can start talking about how the materiality in Escobar should apply to healthcare fraud. And in my amicus brief that I'll file or petition for cert, I'm sorry, my notifications are buzzing here. Or petition for cert, we can cite that paper and hopefully get it in front of the court.
Yeah. So going back to, let's absolutely do that. And, I'm excited about the Ruan ruling as well. I don't want to stray too far away, but I had a fascinating conversation with a former DOJ prosecutor yesterday. And I said, it's really going to be a high level of accountability that is placed onto prosecutors now when it comes to making a determination as to whether or not to bring charges against a legitimate prescriber, right? There's something that our listeners need to understand. There's something called prosecutorial discretion.
Yep.
And in my opinion, in the cases that I've been asked to work on, like the Campbell case, even though I was not part of the Substance Control Act portion, right? Because that's not my lane. I still do a ton of research on it. I understand it. And for me, the district court was the problem, right? Because the district court, I think it was the Ninth Circuit Court that made the ruling on it, but they really kind of hand tied the prosecutors when it came to having to file certain charges. But my argument with this former prosecutor yesterday was that it's not really about accountability on the prosecutor's part. It's about prosecutorial discretion, and it's about not bringing these cases. And I think for me, the Ruan case is huge, because if you think about all of the patients out there that have legitimate problems where they need something to take the edge off of the pain, they need pain management care, not just an injection. They need things for breakthrough pain. We have physicians that have patients that just had surgery under general anesthesia where there's going to be postoperative pain, and they don't want to prescribe anything. They're sending them home with Tylenol because they're petrified of being targeted and charged.
Yeah, no, you're absolutely right. There is a consensus that is brewing right now that the Ruan decision dramatically changed opiate prosecutions. Yes. At the risk of people being upset generally and at me, I don't believe that it will. And here's why. Over the last 4 years, prosecutors have tried to argue, as they did in this case, that the Controlled Substances Act bars a doctor from stepping outside of objective prescribing criteria. That's their new mission. This has only come up over the last few years.
And just for everybody listening, the Controlled Substance Act was a huge part of this pain center case.
Well, yeah, they argued. In fact, I should give some background on that. The government argued that opiates were used to hook patients into the practice by getting them addicted, and then perform unnecessary objections. That theory ended up being complete hogwash, and that's one of the reasons why the jury acquitted. The Ruan decision came out the morning the judge was reading instructions to the jury. Never had that happen in my entire career. Same with the judge. Huge Supreme Court decision. We had to scramble with it, and this is the first post-Ruan case. Okay.
Yeah.
So over the last 4 years or so, the government has started to argue there's objective criteria for prescribing, and if you fall outside of that, you are not being a doctor, and you can be convicted. Prior to that, the government didn't have this theory. And so when they were deciding who to charge, they were pretty much going after the pill mills where the conduct was a little bit more obvious. They certainly prosecuted a lot of close calls, and there were some acquittals out there. But for the most part, the cases we were seeing were a lot more problematic than the cases that we have here. The Ruan decision coming out basically said, objective criteria, falling outside of objective criteria is not enough. The doctor must subjectively believe, even though Justice Breyer didn't use the word subjective, he avoided it for various reasons.
Right.
But the reality is the doctor must have subjectively believed that they were falling outside of their authorization to prescribe. So they knew that they were prescribing for no legitimate medical purpose and outside the course of professional practice. That means the doctor must have knowledge that their conduct is unlawful, and not just that they violated some objective requirement. So I don't think it will stem opiate prosecutions. I think prosecutors will say, okay, we tried to expand the reach of a statute and we got pulled back a little bit. I'm really interested to see what happens in Naum, which is my other case before the Supreme Court. In that case, we're arguing that the standard outside the course of professional practice and for other than a legitimate medical purpose can't be severed. And so the prosecution must show that if a patient didn't have a need for the medication and the doctor stepped outside of their bounds. I don't want to digress too much, but we're going to get a lot more movement in the opiate arena when that decision is out, or if that case gets argued. And I think it would have to be next term because this term closes today.
Yeah, and I'll leave this subject with this. I was really shocked that in the Ruan case, it was not a 9-0 ruling. I was really surprised on that it was a 6-3, but whatever the case, I thought Breyer did a masterful job of, of writing the majority opinion on it.
Yeah.
I found it interesting that he stopped short of overturning the Ruan conviction and remanded it back to, or sent it back to the lower courts. And I think it's going to be really interesting to see what happens there with the two physicians in this case. But we'll keep our eye on that. And obviously, as you're part of the new legal roundtable that we're going to be doing every month, and I can't wait for the last of your cases that are before the Supreme Court to get ruled on. And I think you said it's going to be ruled on today, possibly, right?
Yeah, there may be something in my email inbox from the Supreme Court telling me if I'll be arguing next term in front of the new Justice Jackson and the rest of the bench. Let me mention, Ruan was technically a 9-0. When judges concur, they are agreeing with the outcome, but not necessarily with the reasoning.
With the reasoning.
Yeah. So we'll give them a 9-0 on that.
So I agree with you. I agree with you on the concurrent ruling, absolutely. And I apologize. I should have said that. But
no,
let's go back to the trial, because again, and I wish I could have been a fly on the wall for some of the cross examinations that you did, because to me it was just so egregious. But I'll tell you, normally I know, like from doing this for so many years, sitting on a stand and being cross-examined, I know really based on the first question whether or not I'm in for a heck of a ride, or whether or not the prosecutor is going to have their hands full with me.
Yeah.
And out of the gate, when the biggest challenge that was thrown at me was, well, Mr. Weiss, you're not an FBI agent. Mr. Weiss, you're not an OIG agent. Mr. Weiss, you're not a prosecutor. I thought to myself, if that's the best that they're going to throw at me, well, then on redirect, it's going to be pretty simple to be able to say, no, you're right, I'm not. But after 28 years of working in this industry and employing former FBI agents or retired FBI agents, they hate when I say former because that implies something nefarious, but retired FBI agents, retired OIG agents, working with former prosecutors for the duration of time that I've been doing this, you learn the inner workings of these governmental agencies. And again, you read, you study, you become a master of your craft, and you understand stuff far beyond what even people working in those institutions, in those agencies, actually know. But the other part that was really fascinating to me was the pure lack of understanding for how evaluation and management services work.
Well, this is it. Yeah. Sean, I mean, you hit the nail on that here. First, the prosecutor, I won't name him, and I don't want to malign anybody, but he's no longer with that office. He left the last day of trial. So,
okay.
Former patent attorney, not sure how many trials, if any, in the healthcare fraud arena, and wrangling a very difficult concept, E&M codes and injection codes that many of us have spent our careers on and are still learning, also incident two. When you put somebody like you on the stand, who's just an absolute dictionary of this medical legal stuff and billing issues and healthcare compliance, there's not a question that he could ask, especially if you are well-grounded in your opinion, that would shake you off of what you believe, because he just does not have the mental acuity necessary to understand even the fundamentals of these concepts, but then also to turn them around against you. And I advised Dr. Murphy of this, the other expert, and I think I mentioned this to you. You wait for your opening, and when you get an open-ended question, you deliver that uppercut, right? You answer truthfully and in a tight way, and then when you get your opening, you lay it on the jury, and we score points in cross-examination as well as direct examination. And you did an expert job of that. I'll put you on any stand in this country in front of any jury, and they're going to recognize that not only are you handsome, but you're intelligent as well. And it's good.
That was totally unexpected, but thank you.
It's gonna work out well for the client. You just had somebody who didn't have the experience to box in this arena, trying to go up against somebody. Again, another reason why we've got to start leveraging all of these capabilities that we have available to us in these federal criminal cases. These cases can no longer be tried by the federal criminal defense attorney who's doing a murder, a bank robbery, a child molestation case, and then, oh, hey, I'll take a healthcare fraud case, right?
That's right.
That's not what we can do. We were the only defense team with you, with Vaughn, with the statistical evidence, with a really, really solid expert who laid out an appropriate standard. We were the only team with a very solid opening statement and PowerPoint showing the jury rules and regulations, and a closing argument that was fact intensive, healthcare law intensive, and really showed the jury what the government missed. My defense counterparts did a fantastic job. They all carried their weight during trial. But I firmly believe that without the healthcare knowledge and experience that you and I would bring to the table, we're looking at a completely different outcome in the Payne Center case. And we're looking at doctors in jail and lives shattered, and an impact to the healthcare community in Detroit.
Yeah, listen, I agree with you 100%. And, I get an opportunity to work with a lot of healthcare attorneys, and there's some great ones out there, right? The Brianna Santolis, the Amanda Weshes, the Robert Lyles, the Gabriel Imperados, the Colin Callahans. These are folks that have dedicated their career not only to leveling the playing field for their clients from a legal perspective, but mastering the craft and the complex world of Medicare rules and regulations as it applies to coding, billing, documentation, provisional guidelines like Incident 2. And that was another thing. It was absolutely mind-blowing to me.
Yep.
That they brought up Incident 2, which for me, when somebody brings up Incident 2, I always want to kind of gauge where they're going with it. But the fact that they didn't recognize that you can have any physician who is part of a group practice in a physician-directed clinic supervise the patients receiving the services in the absence of the treating physician.
Yep.
As long as they're there in the facility and they're immediately available to engage if there's a problem. He kept sticking to, but it requires direct supervision. Well, you're right, it does. But it can be rendered by any of the supervising physicians that are part of the physician group.
And Sean, that's only half the story here, because you didn't know this, but when he started trial, he thought that these claims were all fraudulent simply because they were in the name of another doctor. He thought that a physical therapist, when they render a service, must bill in the physical therapist's name. And if a doctor bills physical therapy, they're telling the insurance company that they perform the physical therapy. Same thing with the other visits. He just didn't know. And then when we cross-examined his agent on Incident 2, and there were literal crickets in the courtroom when we were asking him about these concepts, he then pivoted and tried to argue that Incident 2 isn't applicable. And the jury could see that he was learning healthcare law as he was going through the trial. I even said that in closing argument. You could tell the government was learning, which tells you everything you need to know about their investigation to begin with. This isn't the time to start making up theories, right?
Yeah. Eric Rubenstein tells me all the time, I would, and I never thought about it until he said it like 2 or 3 times. He's like, you would have made a great OIG agent because you're objective and you're reasonable and you use processes to be able to make a determination as to whether there's any there, as opposed to just simply jumping to a conclusion. You
Yeah.
create a hypothesis and then you try to prove that hypothesis wrong. Um, this case, just like the Jeffrey Campbell case, that, I got, to work with you on, I think it was last year.
Yep.
So
Exactly
this
this time
two
last
criminal,
year.
two criminal cases in 1 year. That's
Yeah.
so. I'll tell you what, I tell people all the time, for me, this is a ton of fun. I have a lot of people that act as experts and they're like, how can you even think this is fun? Well, because for me, when you study and you engulf yourself in something that you are truly passionate about and that you can speak intelligently about, and you can take complex matters and break it down into plain language for people who don't work in this industry to be able to understand,
Yep.
it becomes fun. And it was kind of fun for me watching the jury, because you did a phenomenal job. Seriously. I know some of the listeners are going to be like, oh my God, this is like a bro fest or something, but this is the truth. I wish they would have like a CCTV or something where you could watch some of this stuff.
Yeah.
Because what Ron did during the direct examination, which I think should be taught in, direct examination 101 in law school. He asked simple questions. Sean, is there any guidance or regulations that exist in Medicare for how an audit takes place?
Yep.
Well, and then and that was it. It wasn't, this long, complex question broken down into 27 parts.
Mm-hmm.
It was a straightforward question. And the simple answer was yes. Chapter 3, section 3.2.3.4.
Yep.
And it specifically talks about the following.
Yep.
Sean, is there any guidance or instructions as to law enforcement engaging in audits for Medicare? Yes, there is. Chapter 4. Sean, is there any guidance or regulations regarding statistical analysis and how and when statistical sampling can be deployed? Yes, there is. Chapter. And it was so easy.
Yep.
And I was watching as we were going through our direct examination, watching the members of the jury kind of looking at each other going, what just happened? And then watching them scribble down notes, right? Trying to, what is that section? What is that chapter? And then at the same time, I'm not sure who the gentleman was that was sitting behind the prosecutors in the first row, but like he was frantically writing notes on these yellow stickies and handing it to him. And I'm watching the two prosecutors looking at each other, literally going, shrugging.
So that was done for a very specific purpose. Trials are about closing arguments. You can score points in terms of momentum during the trial, but it's like regular season and playoffs, right? You've got to do well enough to get, and get through the regular season in order to make the playoffs, but the playoffs are where you really show up. Closing arguments, the playoffs here. So I'm inviting curiosity and not really closing the loop on many of these concepts with the jury by just saying, hey, Sean, what is this? And what is this? And what is this? And, let's talk about that. I don't expect a jury to really put all of that together and why it's important until the closing. But the two things I want to do during trial before we get to closing is I want them to think with a skeptical mind and erode the prosecution's credibility. And then I also want to invite their curiosity and whet their appetite to certain concepts so that they're eagerly listening to the prosecution going, I wonder what Ron's going to do to tie in some of these things that we learned about. And I wonder if he's going to show me why these are important for this case. So that's the vital role that you played. You whet their appetite with some rules and regulations that applied, and we didn't have to go too deep. In fact, I didn't even ask you to opine on anything that was done in this case or review any records. I just wanted you to get up there and say what the regulations said, because in closing, we showed that the government had this huge burden and we're supposed to do all of these things, and they didn't do any of them. And I talked about you heavily in closing. I'll share some of the closing slides. I'm going to do an article on Federal Defense Blog that goes through the trial strategy so that other people can get a hold of it. And if they want to use our suite of capabilities available for their healthcare fraud cases, they can do it. So that we can provide benefit to the community and save doctors from getting, hurt by these aggressive policies. I will admit, Sean, I committed an egregious podcast violation a few moments ago. I checked my email, and in it were two emails from the Supreme Court of the United States. The first one was vacating the Fourth Circuit judgment in Naum versus United States and remanding it back, which means he's overturned. And the next one was vacating Couch v. United States and sending it back. We expect that at some point, both of those circuit courts of appeals will take a look at them and potentially vacate those convictions, which is what we're looking for. So great news all around this week.
Is there a white collar attorney Hall of Fame?
Well, I don't know. Maybe they need some of those, like the podcast awards that you're getting all over the place. Maybe we need some awards like that. The only awards that there are in the legal field are the ones where you have to pay your $300 and then you get your name that you can post on your website. And I don't do any of that stuff.
Super lawyer or something like that, right?
Exactly.
Yeah. So here's the last question that I have for you.
Mm-hmm.
My understanding is it took the jury only 10 hours to deliberate. Now we're talking about a 7-week trial, okay? 10 hours approximately to deliberate and return a verdict.
Yep.
Prior to the reading of the verdict, were you nervous that they were able to come back so quickly with a verdict?
I shouldn't admit to this, but I'm going to because it's you. You're like the sports reporter on Jerry Maguire where you get everybody to cry. You remember that? I hope some of your listeners remember that movie.
Show me the money.
Yeah, exactly. I wrote the press release before I walked into court that morning. I knew what was going to happen. I could see it. I would not normally be so presumptuous, but I knew the night before that the jury would have a verdict in the morning. And I knew that this was a diligent and attentive jury. And I knew that if they wanted to convict these guys, they would look through the evidence. And 10 hours isn't enough time to, let me put this into perspective. The jury can't talk about the case until they go to deliberations. And I don't know what happened in that room. And that's all between them. And I don't care too much. But 10 hours isn't enough time to really figure out where the evidence is and start looking at it. I think they walked in there, they took a couple of votes, they realized that the government's credibility had been completely eroded, and they ran the score sheet 54-0 in favor of the defendants here. And one of the most beautiful moments in my career will be watching those handcuffs taken off of Dr. Bothra, who'd been in jail for 42 months, and watching his daughter give him a big hug, and there wasn't a dry eye in the courtroom. Dr. Edu's wife came up and gave me, the most heartfelt hug. I held my composure until just about that moment and started to feel some things. And it was just an incredible victory, but I am very irritated that the government has put those people in that position. I think that it's an absolute abuse of power to continue to apply what should be, these civil issues in a criminal context. And I hope that we in some way have eroded the U.S. attorney's faith in their prosecutors to get these cases off the ground. And if I'm litigating myself out of a job, that's fine. Because if that means one less doctor gets hurt by what's been going on in this country, I'm okay with that. We'll find other things to do.
Absolutely. I lied to you. I had one more question.
Yeah.
But I will say this in keeping composure, because that was one of the things that's always hard, right?
Yeah.
After I got off the stand and, the court adjourned, I think it was for lunch, having Dr. Lewis come up to me with his wife, and I think that was his parents, and saying the heartfelt things that they said to me. Because I'm not a very emotional person. I'm a regulatory guy, man. I'm black and white. I don't have any feelings, you know.
CMS didn't give you emotions, Sean. They would put that in the regulation if they wanted you to.
But to me, that was the greatest reward. Was having the defendant and their family coming up to me, telling me how much they appreciated what I did and what they thought of the testimony that I gave. But I said I was done asking you questions, but I lied. I have one more question for you. Originally, there were 6 defendants in this case, of which 2 of those defendants decided to take plea agreements, and they broke from the other 4. And I'm just wondering if there's any regret on the part of those 2 physicians, given the fact that you all were able to achieve a total acquittal.
Yeah, so those 2 physicians, hired attorneys who've done healthcare fraud cases before. I know them very well. They're very good attorneys, and I'm sure that they would have looked into their client's specific circumstances and realized that maybe it wasn't worth the risk, or maybe there were particular things about their conduct that was problematic, and advised them. The unfortunate issue for them is they've pled guilty to federal offenses pursuant to plea agreements that will subject them to sentencing by a federal judge, Judge Murphy. And the federal judge is not going to think about the fact that the other physicians got acquitted when handing down that sentence. So you will have 2 people that will be in jail for conduct that 12 jurors determined was not outside the line. It's a shame.
Yeah.
Some may say, and I think are already saying on Twitter, you sort of get what you deserve. I think it's unfortunate because those 2 people had to make a very difficult decision. I have no ill will towards them, and they had their own issues to consider. But let's face it, going to federal trial is rolling the dice. I mean, our outcomes have been great.
Yes.
4 out of 5, with 1 just got getting vacated. We're damn near 5 out of 5 right now. But that's not the case for everybody. 99.5% of federal defendants get convicted. These 4 defendants who were acquitted are rare, and those physicians had to make their own decision. I hope the judge goes easy on them, maybe hopefully without some jail time, but they do get the benefit of their bargain at this point.
Yeah, that is true.
Yeah.
All right. Well, this brings us to the very end of this special edition podcast with my really good friend, Ron Chapman. Super attorney. I'm telling you, if there's not a white collar attorney Hall of Fame, there should be. And he should be, in my opinion, the first inductee. It's been nothing but a total privilege and an honor to be able to watch you dance like Fred Astaire in the courtroom, and to watch how you control a room when you are, at that podium. So with that said, counselor, thank you so much. I know, again, you had 2 decisions vacated today at the Supreme Court level. That is huge, 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 huge. The Ruan case being remanded back as well. Basically, it's vacated and it's being sent back to the lower courts. I mean, that's a huge, huge win. And I think we're going to really see what comes of that. Congratulations on one of the largest healthcare fraud trial acquittals in my lifetime that I'm aware of. You deserve all the praise that goes to you. Folks, again, I say it on every podcast when we talk with healthcare Senate attorneys. This is why you use somebody who is a master of their craft. Don't get somebody who's handled your 3rd divorce, or who handled your trust, or who put together your estate or something like that. You're just asking for problems. Get with the right people. And if you don't know who to call me, and I'll get you to the right people. or to the right person. All right. With that said, as always, thank you all so much for tuning in, logging on, and hanging out with us for just a little while. As always, remember, be good to yourself, but more importantly, be good to each other. And until